Many of the rules of court direct, obviously, that a cross can't go beyond the scope of direct. And I'm wondering if, A, Texas has that rule, but more importantly, how rigid were you in enforcing that in your courtroom?
We do have that rule, but I always viewed my role as a judge to simply be right there and call balls and strikes, as the Chief Justice has once said. And so I'm not going to prohibit anything unless it's badgering the witness or approaching the witness unfairly, unless the other side makes an objection. If the other side didn't make an objection, then I'm not going to make a comment, because someone may view that to be a comment on the weight of the evidence. So if they go beyond the scope, it's up to the other side to make the proper legal objection.
And legally, you would feel bound then to sustain that objection if they went beyond the scope, or do you provide some leeway to that rule?
No, I'd like to keep it tight, and certainly if the proper objection is made, and then it will be sustained.
Okay, great. I came across this quote from Irving Younger, who a lot of people know is a famous author and attorney on trial advocacy. But he said that a short cross-examination was always the best, and he is said to have said that a cross-examining attorney should make 3 points and 3 points only and sit down. Comments on that?
Well, obviously he's a very well-respected commentator and very well-experienced, but sometimes your 3 points may turn into 5, but great cross-examination, and we just saw 3 very, very good ones, are generally short. You get your point across, and obviously the secret to a great cross-examination is knowing when to sit down and not ask the next question, even though it's very, very inviting. Get your point across and get it done.
And on the subject of the next question, I guess, there's also the old adage that you don't ask a question that you don't know the answer to. Is that always true? Is it too limiting, or are you taking too great a chance if you have to go out there on a limb a little bit?
I think that's the safe bet. Unless you know what the answer is, don't ask the question. You don't want any surprises. The general counsels, the associate general counsels, the claims managers, they don't want any surprises, and so you shouldn't create any. And that's effective cross-examination.
So effectively, you should know your cross and the answers before you even walk in the courtroom, period.
Absolutely, and know your transcript, your deposition transcripts, so that you can impeach the witness appropriately. I think you may have saw some of that with Fran when he was up here earlier. He asked a question, the witness was not being responsive according to a deposition that was taken. He had it right there and ready to impeach, and that's very effective.
Great. How about, all judges are obviously a little different, and some will allow more leeway on different points. Some are very, very tight on the rules, et cetera. Does it make sense for a lawyer, certainly to talk to other lawyers, but does it make sense for a lawyer to try to sit in on a trial, to actually get to know a new judge, to watch them in action, watch them try in a case before they get up there and actually try their own case?
I absolutely think that's very important if you have the time. If you don't, certainly ask your colleagues, ask around, ask people that have been in front of the judge, so you can have an idea of what that judge, what he or she allows. I think that's very, very important.
This is sort of an interesting one. Should a lawyer's fundamental approach, and you may have already answered this, but I want you to think about it for a second, to cross-examination of a fact witness differ in any material aspect from an expert witness? Cross.
Yeah, well, I think so, and in that the facts are what they are, obviously. You don't want to, you can't create the facts. And I've always said great facts make great lawyers. And if you have bad facts, and you need to stay, get them out there, but stay away from them to the extent that you can. With a expert, that's a hired gun. That's a person that's come in to deliver testimony, generally one way. And you go after that expert just like you would a hostile witness. You show how their methodology is wrong. You go after every piece of their testing that you can do. And I think that's a lot different. And it's okay in that situation, I think, to respectfully go after some of these experts, because I think the jury comes to believe that they're also paid experts, and that comes out during the examination. How much are you charging an hour? $1,000 an hour to come down here and give testimony. So you would expect the testimony to come out one way.
We all know that the real purpose of cross is for the attorney to testify. But we saw you admonish one of the attorneys today because he got too close to the witness, certainly without permission. So maybe a couple words from you on the effective use of the attorney's body in cross-examination. Should they be moving around? Is it more effective to stay in one place? Obviously, seek permission to approach if you need to, but is that an effective strategy, or do you need to be real careful that you don't appear, as we heard earlier, to be looming over a witness, that kind of thing? So just your thoughts on really the effective use of movement in the courtroom on cross-examination.
I think movement can be very, very effective. But from my perspective, you have to keep in mind that the jury wants someone to be in charge, and they expect that person to be the judge, the presiding judge, and not the lawyer. And so the jury is expecting control in the courtroom so that you're not wasting their time. And, of course, you want the lawyers to move along with their case. But I think it is effective to move about the well if you have permission. And in Texas, you have to get the permission from the judge before you can approach a witness, before you can approach the bench. And I think that's the general rule throughout the country. But you don't want to be a distraction either. You don't want to be going back and forth. But you certainly can position yourself, for example, the jury box. If you want that witness to talk to the jury, then I may go stand behind the jury box. So they're looking at that jury, and you can see them lying, or you need to impeach them. And I think that's very, very effective. You don't want to sit there and read your transcript, read your deposition. You stand up, move, but and then if you can't approach the witness, for example, to introduce an exhibit, stay there until the other side objects or until the judge moves you, because that's, in my opinion, can be extremely intimidating to a witness. You may catch them off guard and get some testimony that perhaps you may not have gotten otherwise.
And on that last point, and then we'll wrap up with one more question, you, even despite your best efforts, you may script out the whole thing, but as you said, it's a common mistake in a deposition when people just read from an outline and don't actually listen to what's being said. So you have to react at some level. But let's assume you get, as these poor attorneys, we put them through, a bad answer, something you weren't expecting. For whatever reason, a witness goes back on something they said and they want to try to explain it away. Is it, best practice, is it most effective to soldier on through that, or do you have to address it?
It depends. I mean, being a trial lawyer, you're a true warrior. You're in there, you're trying to get information, you're trying to win this case at the district court level, and you have to make split decisions. And I'm a martial artist, and like Bruce Lee says, you have to be like water. You have to adapt. And if you get a bad answer, you have to think quickly. All right, do I need to explore that? Do I need to go right through it? I mean, that's a decision you can only make during when that happens and in your particular case. I don't think there's a right or wrong answer for it. I think you saw 3 very good lawyers do 3 effective cross-examinations. The first lawyer, he avoided all the mind traps. That's incredible. You have, either by chance, by luck, by skill, or otherwise, but he did that. And maybe a couple other lawyers fell into a little trap, but they addressed it. I thought they handled it properly, and then they went on, so that the jury's not dwelling on it.
And lastly, again, we're looking for universal tidbits. Cross-examination, you should never.
I think you should never ask more questions than are needed to get your point across, and whether that's 1 question, 2 questions, or 3 questions. The jury is a lot smarter than you think. They want to get to the end. They don't want their time wasted. And short, effective, say what you mean and mean what you say. It works most of the time.
All right, thanks to the judge, and back to work for you. We'll move on now.